Right. Well, good evening, everyone, and welcome back. Welcome to those who are joining us from today. Yesterday, in her first and wonderfully engaging lecture, Professor Beth Simmons introduced us to her ongoing work on borders, which is based out of the University of Pennsylvania, where she's at, and is funded by an Andrew Carnegie Fellowship, a National Science Foundation grant, among other grants. Yesterday, Simmons talked to us about a shift in political and popular imaginations across the world that is marked in the rise of border anxiety and in assertions of unilateralism in the setting and perception of borders. She made us think about the discourse of border exceptionalism and about the strangeness of increasingly familiar language of sovereignty. And she left us with the promise that today, in the second 2024 Hersch Lauterpacht Memorial Lectures, she will explore the cooperative roots of international bordering and border governance. We are eagerly looking forward to this.
Thank you so much. I appreciate that introduction. And for those of you who I saw last night, thank you so much for coming back. That's nice to see a few familiar faces. And I take that as a positive sign that we have something to talk about. So I very much appreciate that warm welcome. And as promised, I'm going to try to talk about the cooperative roots for international bordering today. And I especially want to thank my Mexican friends for being in the front row, because I'm going to start with a case that's going to be familiar to you. It is a case that came to the United States Supreme Court in the 2000s. And it began on June 7th, 2010. When a 15-year-old boy was playing with friends near the U.S. border. And it's going to help me, I think, to introduce the rest of the points that I would like to make. And just wondering why this isn't advancing. So I'm going to introduce it with this case that involves, again, a case on the U.S.-Mexican border, probably familiar with. And I'm going to use that case sometimes in this lecture today to talk about the assumptions that we make about international borders and try to reframe these as places where international cooperation should be possible. This case is really interesting for that because this was an instance in which we had a majority opinion in the U.S. Supreme Court and a minority opinion. And those two opinions took the two almost ideal type kind of view that I would like to compare today. So first, I'll be talking about reframing borders as institutions. And then from there, talk about bordering and making the move from bordering, drawing a line, to border governance. And from there, be thinking a little bit more about the tools that we have in international law to actually draw out some of the cooperative routes to international bordering and then draw some conclusions. So the case I want to begin with is the case that involves, in 2010, an unarmed 15-year-old boy who was playing with friends near the international border between U.S. and Mexico, just outside of El Paso. So that would be in Texas. And they were playing a game that involved running back and forth across the culvert, in which the boys were sort of, I don't know, it could have been a little bit of a teasy game maybe for the border control, but they were touching the other side of the border and running back. So they were kind of going back and forth across the border. The boys attracted the attention eventually of the Customs and Border Patrol. And the agent involved was Agent Jesus Mesa, and Officer Mesa rode up on his bicycle and he detained the boys. One of them, though, escaped and ran back to Mexico. And his name was Sergio Adrian Hernandez Guerra. And he retreated back onto the Mexican side. And within just a few minutes, Agent Mesa was standing still on the American side. He was standing on American soil, but the young boy was on the Mexican side of the border. And he pointed his gun, the agent did. He took aim at this retreating teenager. By now, he was in Mexico and retreating. And he fired at least 2 shots at him. One struck him and killed the boy. And so this case for me is such an important one in a couple of ways. I think that anytime we have the death of an unarmed boy at the hand of a border agent of a friendly nation, it should raise some pretty serious questions not only about how states recruit and train their border agents, which it certainly does, but also how we think about the border itself. So the Hernandez family, they filed a civil case, and it made it eventually all the way to the Supreme Court twice in the United States. And in the Supreme Court decisions, we see two very different conceptions of the international border. It emerged in both the minority and the majority opinion. The major view, the majority view, was expressed by Justice Alito, and it emphasized the border was a dangerous place. He wrote that, quote, "The Customs and Border Protection Agency is responsible for preventing the illegal entry of dangerous persons and goods into the United States, and the conduct of their agents positioned at the border has a clear and strong connection to national security." Now, American law students don't read this case to study borders. They use it to study jurisdiction. They use it to study essentially federalism kinds of questions. Who in the United States should be handling this? Essentially, the Supreme Court declined to handle this case and to handle the issue of a remedy to the family who was suing for some kind of remedy or compensation for the life of their son. So I read it, though, for the reason that maybe all of us in this room are much more interested. It's assumptions about the nature of the border itself. And for me, it raises the issue and just the question, what are these inscrutable places that we sort of always see a national security interest involved? They presumptively raise issues of national security. That's what the Supreme Court essentially said. The court declined to provide a remedy because, quote, "a cross-border shooting claim has been ruled to have distinctive characteristics with national security implications." So this was a job for the political branches. It wasn't a job for the court to even deal with. So the court declined to make a decision, essentially. And this case really struck me for what it says about international borders and human rights. Borders are widely presumed to be security tripwires, and not just in the courts of the United States, but increasingly around a number of countries around the world. The national security assumption is built in and built upon an even more insidious assumption, and that is that borders are constitutive of state sovereignty itself. And as such, some conclude they need to be enforced at all costs, as I was discussing yesterday. So I feel like we need to critically, very critically, review this assumption and to offer an alternative today in this lecture, to consider instead borders as social that serve a collective purpose of the international community as a whole. International law forbids, as I will talk about in this lecture today, forbids unilateral change of a border. And by looking at that, we can see how a collective social purpose exists in stable coordination around territorial jurisdiction. And borders, in this sense, are coordinating mechanisms in the service of the norm of territorial integrity. And then I'll be pivoting to other norms that have to do with the governance of borders as well. And that's where human rights will be brought in. Okay, so it's around this idea of the collective interest of the international community as a whole. So intuitively, I think, unilateralism is impermissible. It's impermissible in border maintenance as well as border drawing. So I'm going to start with treaty law. Okay, that's the law about where you find sort of the rules about how borders are respected in terms of international treaty law, about their determination, essentially. And I'm going to pivot to this question of the maintenance. But I'm going to claim that unilateralism is not permissible means of border maintenance either. Okay? And yet the collective good in rule-governed border maintenance to me seems very obvious. The international community has a collective interest in fundamental human rights. And there's good law to apply here that I'll try to discuss today. Namely, we're going to draw from general principles of law and the international law of good neighborliness. Perhaps least intuitively, I will argue that the legal creation of borders and their proper maintenance are actually connected. The connection hinges on the utterly foreseeable consequences of the act of bordering itself. Okay, so when a line is drawn, and if it's a meaningful line to maintain jurisdictional autonomy of various kinds, consequences followed from that. Predictable consequences followed from that. Borders are in some ways wedges that alter relationships between communities and groups of people. In so doing, they create issues and problems that need to be managed, and those issues need to be managed cooperatively. So I think that's somewhat leads into it, that these things are connected. The benefits of claiming territorial integrity, territorial sovereignty, comes from the responsibilities to one's neighbor in the international community more broadly of maintaining territorial sovereignty in a responsible way. No more can the international community tolerate harmful border control practices than any community can tolerate a property owner, for example, who uses their property to violate community standards of decency. So we're going to be talking about some of the principles of international law, general principles of law that might be relevant in this space as well. Now, no, my purpose is to add to, but not to detract from legal ammunition from universal human rights treaties. One might have thought that these should have been enough to make some of the points that I'm going to make this evening. Is actually obviously a universal declaration. It touches on a broad range and has given rise to a broad range of legally binding treaties that have been signed and ratified by the overwhelming majority of states in the world today. And we know for the most part, and I believe, and my research suggests that for the most part, these treaties have contributed a lot, very positive, to human rights. And we know that the core of international human rights are now in constant custom as well. And yet, claims of national security and notions of border sovereignty are starting to encroach on what we know are unassailable legal obligations. And I want to resist that logic, the logic that conceives that the border is somehow a battlefield where human rights become a second order concern. The idea that enforcing international borders is somehow a justified exception and I think that should be challenged from more than one direction. So what I'm going to do is challenge it today from the perspective of cooperative obligations around bordering. In addition to this universalist approach, which I fully believe that I'm fully on board with, I'm offering one built from the ground up this time that anticipates and hopefully delegitimates border exceptionalism. Okay, so let's sort of turn now to this question, thinking about borders as cooperative institutions. Let me start with a little bit of a disclaimer before saying another word about borders as cooperative spaces, about this thread that I want to draw through the rest of the lecture. It's essential that I really do make one thing very clear. I'm fully aware this is counterintuitive, and that's okay with me. This idea somehow of using borders and celebrating their cooperative nature, I understand, is in contrast to a lot of what we know about the historical process of territorial consolidation in the state, which has historically been far from cooperative. The process of forming a system of territorial states was violent. I acknowledge that right now. And until the early 20th century, conquest of terra nullius was viewed as somehow a legitimate way to establish political authority. Consent to the acquisition of territory through treaties was a fable. I understand that. Coerced treaties and concessions were imposed throughout the non-European world and in Europe itself, at least until the founding of the League of Nations. Territory was considered a legitimate spoil of war. The consequences, of course, have been significant. They've been significant throughout the world, but they've been especially significant, for example, in parts of Africa, where the colonial borders were accepted under the principle of iuditas status. And what this often meant was that they did not match up with ethnic groups. They didn't match up with realities on the ground. They often created geographies that were hard to sustain as independent states. I think that all needs to be acknowledged. The idea, though, of iudipos edatus was accepted by African elites in their understandable interest to try to eject European power from their territories. So given these injustices, and thinking of borders as cooperative institutions may seem like a little bit of a jump, a little bit counterintuitive. And while I can admit that iudipos edatus made a mess of a lot of the world, and what I mean by that is some of the difficulties, especially in consolidating states around unnatural borders of various kinds, it was accepted as a stabilizing principle for international relations. To be sure, there's nothing democratic about this. I will admit that right up front, about this process. But the bargain between receding colonial powers and the first generation of emerging independent leaders was that ejecting Europe was the top priority. And stabilizing the emerging system was the idea behind accepting this principle. And it apparently represented the first order problem of self-determination for much of the world. So the idea that borders are somehow cooperative institutions is not intuitive kind of from a realist international relations perspective either. And here the argument is just a bit different. It has to do with the idea that borders actually are not cooperative institutions, they are mere truces. The world of bordered states is seen as a world of zero-sum in which my access to territory is limited by your claims and only your ability to sort of maintain that claim somehow forcibly is what keeps states in check in terms of territorial aspirations. So in this sense, borders are seen as sort of zero-sum dividing lines, the way you cut the pie, and no state is ever going to be satisfied with how much pie they've got. And instead, many are waiting in the wings for their moment to revise these lines in their favor. And I thank you very much, Mr. Putin, for demonstrating to us that that is, in fact, a lot of what goes on around international borders. So that's an obvious example of that. But I do think there's been a very important kind of a pivot in the middle of the 19th century, an effort to reset norms around territoriality and borders. And so this is when, of course, as I mentioned yesterday, the territorial integrity norm, the inviolability of state borders constituted the core norms of interstate relationships, as reflected both in the Covenant of the League of Nations and especially in the United Nations Charter. And so this is when now we are increasingly seeing themes of order, clarity, certainty, and especially stability running through the international law of borders. For the sake of systemic stability, only the peaceful agreement of states involved is seen as a legitimate way now to establish or especially to change international borders. So from an interstate perspective, borders were stabilizing because they were essentially this kind of a coordinating mechanism between states. Maintaining the territorial integrity norm is tricky unless you know where to maintain it, right? If you're going to have a norm, you need to have sort of a mechanism that makes it possible to know if you're within it. And that is what the law of bordering has done, essentially. And there's plenty of evidence to suggest that states saw a lot at stake in trying to maintain this sort of clarity around international borders. And the theme of clarity around international borders is really clear in practice as well. So there are just many, many instances in which the United Nations, after, for example, a decision on the part of the International Court of Justice or some other institution, or at the end of a negotiation, has suddenly said, now we'll support your process of demarcation. So it is this kind of idea that the international community more generally has supported these norms as well. So there's no formal rule that obligates states to delimit their international borders by treaty, let alone demarcate them on the ground, but they're strong norms of the international community. And the reason is very clear. Although people have lived for thousands of years without legal borders or visible markers separating them from nation states, modern international relations interprets the delimitation and demarcation process as signs of mutual acceptance of international borders. A lack of a contestation is taken as a signal of good neighborliness and is sometimes a precondition for other forms of border liberalization. And I would point to, for example, the cooperative demarcation of the border between Kosovo and Montenegro, which was practically a precondition for liberalizing the visa regime and other relationships between these two countries. So we can some other instances in which the United Nations got involved in clarifying bordering as well. The UN considers adequate the limitation and demarcation of borders critical after the first Gulf War. For example, the Security Council unanimously passed Resolution 833 calling for border demarcation between Iraq and Kuwait. And as soon as the ICJ had rendered a decision in the Nigeria-Cameroon case, the United Nations promptly called for the creation of a commission for demarcation. So this is something that very strongly the international community has a strong interest in. Now, to be sure, borders have not always managed to secure the peace. That is for sure. For example, we could give a lot of examples of this: Ethiopia and Eritrea, Sudan and South Sudan. But I would argue that over time, borders have actually served as effective coordinating mechanism. And this is not some mystical sort of claim that they're charms that convert enemies into friends or stop illegal aggression, but they do tend to kind of create focal points for states to understand what their legitimate aims are. And so it's very interesting to me that we can actually see this in terms of state behavior. And this gives you a little bit of a sense of that, this piece, this picture right here. What have we got? We've got two axes here with data for the number of borders in the world, because of course, over time from 1920 to 2020, so 100 years time, there are many more states in the world, to be sure. That's what this red line is showing us the number of borders in the world. So the number of states going up. That's this axis here. And then we have over here a data set that international relations scholars have put together called conquest attempts. Attempts to take by force the territory of a neighboring state. Okay? And what we see here is, by the way, it's a different scale. That's why we have two separate axes. And what we see here is, interestingly, the process of the versioning of states over the course of the 1980s seems to have been managed pretty well by the idea of clarity in bordering, the idea of border stability. Even though borders have gone up, we see a fairly remarkable decline here in efforts to take territory. These are the number of efforts here to take territory by force. This conveniently ends in 2020. So we know there is a major historical event that would upset, cause a tick up, and a crucial and important tick up, not a minor in this picture. But nonetheless, I think this historical trend is really quite interesting. So it strikes me, though, then that we can see why there might be an interest in a general community interest at the international level in clear bordering. All right, so now let's think about the special status then that border agreements play in international law. And in particular, the special status of border agreements in treaty law. Borders help to support a fundamental value of the international community, that stability, and trying to avoid international conflict. The international community as a whole has this interest in international peace and security. And to that extent, I would argue borders are exceptional institutions. Yesterday, I was arguing they shouldn't be exceptional in terms of international human rights law. Today, I'm going to make the opposite point, that they are exceptional in one important way. They're exceptional because the international community wants to protect and maintain them. Okay, so the exceptional nature is a little bit flipped in this discussion today. In contrast to the view that the border sovereigntists, at least part of the reason for their special status is collective. Okay, we all have an interest in nonviolent approach to borders, and if this is the case, then the exceptionalism of border sovereigntists that they attach to the border should be turned on its head. Institutions serve this collective interest, and states should precisely not be allowed to use their borders on their own unilaterally for national interests that contradict some very central, clear value of the international community as a whole. And I think we can turn to treaty law to get a little bit of a handle on this. Okay, this conception of a common interest seems to have been front and center as treaty law was codified over the course of the 1960s and 1970s. So a fundamental principle of treaty law is that states cannot be bound without their consent. Well, that's International Law 101. States cannot be bound without their consent. Border treaties are a rare exception to that. First, states cannot unilaterally withdraw from or terminate border treaties unilaterally. Okay, so the Vienna Convention on the Law of Treaties specifically exempts border treaties from its rebus extantibus provision. For example, fundamental change in circumstances provision. As such, border agreements are an example of a very small class and almost unique, but I can't be sure of that. But it's a very small class of treaties from which states cannot withdraw unilaterally in the absence of a termination clause, even if other conditions, which might normally justify treaty termination, have fundamentally changed. So I think that's an important exception. Of course, you might think that this was a principle that was not cooperative, it was imposed. And so I went back and I looked at some of the travaux préparatoires that gave rise to the negotiations of the Vienna Convention on the Law of Treaties. And in fact, what I found when doing that historical research was that newly independent countries who you would think would be, and in fact were, centrally concerned with the issue of self-determination, asked about it. They did sort of say, what about self-determination here? And it was decided that these two principles could work on separate tracks, that they would essentially be satisfied independently. That if there were some way or reason to go back and renegotiate a treaty later on, that could be done cooperatively, but not unilaterally as a matter of opting out of a treaty. Okay? So I think that's a very important and interesting observation. A handful of states did offer amendments to what became this rebus extantibus exception to the VCLP, but none actually had any amendment to offer about the territorial exception, which had the border treaty exception, which I thought was very, very interesting. So secondly and relatedly, border agreements had a special status in the law of state succession as well, which was codified over the course of the 1970s. And the result was the Vienna Convention on the Succession of States in Respect of Treaties. And the result was, essentially here that newly formed states would have a right to essentially a clean slate when it comes to their treaty obligations. So they are newly independent. They do not have to be bound by. They can terminate, for example, their previous agreements in the interest of their self-determination and their independence, so that they can create their own sort of portfolio of international obligations. But again, border treaties are the exception to that as well. Successor states continue to be bound by pre-existing border agreements, essentially. So unlike other treaties where new states have the option to give notice, border agreements are more permanently inherited. They're not fully consensual. As a result, as Shaw, who's a major scholar in this area, has concluded, when interpreting border treaties, unilateral modification is not possible. One final point, though, and there's an exception to the caveat. So that's the caveat. There's an exception to it, is that the newly independent states wanted to be sure that they were not bound by invalid treaties. Okay, they wanted still to be able to litigate the invalidity of the treaty itself. And so that discussion was also very visible in the travaux of the history leading up to the negotiation. So what they decided was essentially what I was saying, though, was if the treaty is invalid, it can be renegotiated, but a case would have to be made So cooperation and negotiation, yes. Unilateral revision, no. So I think that's really kind of a very important point to think through and treat on, and just remember why it is the case that there is this kind of unusual exception in treaty law. It's the fundamental importance to the international community of international borders. And finally, we all know that treaties cannot bind third parties. You know that. That's a fundamental principle of. And yet international courts and jurists have hypothesized that certain kinds of boundary agreements can in some cases have legal effects for third parties. Most notably when they create objective regimes. Now, I've been puzzling over this idea of objective regimes here for the last couple of months, actually. I'm not sure I have my head around them completely. So please come on Friday and straighten me out if you know a lot about objective regimes. But this is the way I understand objective regimes. These are agreements in which parties intend in the general interest to create a regime of obligation and rights for a particular region, territory, or locality, which is subject to the treaty-making competence of one or more of them. So the kinds of things that they have been used for historically are things like international waterways, neutrality regimes, demilitarization regimes, and that kind of thing. And so it's interesting that these kinds of regimes are hypothesized to have effects erga omnes. That it's not just a matter of a set of states that negotiated that treaty if they are addressing a matter of general concern, and if they intend that it affects the rights and obligations. Just say effect. I won't say obligations, that might be far, but it has effects on third parties. It can have effects erga omnes. And I want to put that out there because I want us to at least think about if what I'm saying about international border agreements is that they do provide a kind of a public international good, whether they would qualify as a regime that we might think of an objective regime. Okay, so I'm not sure. I'm not sure on that. But if they do, there's another big exception to consent, isn't there? The idea that an agreement that is made by a subset of states, or maybe two states even, could have potentially effect erga omnes. So, I'm not imagining this. I don't fully understand it, but it has been mentioned in a couple of cases of boundary agreement arbitration. Arbitrators in the dispute between Yemen and Eritrea, for example, hinted at a possibility that there might be some kind of regime that had been negotiated in the territory of the Hamish Islands that might have effects erga omnes. And they said, quote, boundary and territorial treaties made between two parties are res inter alias acto, vis-a-vis third parties, but the special category of treaties also represents a legal reality which necessarily impinges on third states because they have effects erga omnes. So it's interesting to think about what kinds of agreements states might make around their territorial division agreements that might also potentially have effects erga omnes. I'm going to say more on that tomorrow, by the way. Okay, but let me put it out there just for now and instead sum this up. Where are we in treaty law? International border agreements that divide territory between sovereign states are the fundamental cooperative international legal institution of the modern state system. They exist to provide a public good, the systemic stability for the entire international community. They're not legitimately created nor changed unilaterally nor maintained as mere private deals between two states, okay? So between contracting parties, a private deal or something like that. Border law preserves a common interest of the international community as a whole, as reflected in the territorial norm of the United Nations Charter itself. So what I'm not claiming that every international border is uncontested. Of course not. There is contestation around international borders. Border disputes are an undeniable aspect of international relations, but the law is devised to coordinate exactly these problems. It's meant to handle kinds of issues. And what I'm inferring from this discussion is that sovereignty indeed belongs to the bordering states, but border rules are the concern of the international community as a whole. And that's what we're seeing, I believe, when we look carefully at treaty law. Well, let's turn from this for a minute now to the question of drawing the borders and its interest in international stability to the question of governing borders. So, there's a jumping off place here. I mean, now thinking about what the common interest of the international community is around border governance. But at this point, you might be wondering, what is all this sort of state-centric talk of stability and international collective interests and borders as institutions have to do with human rights? How do borders as interstate institutions focused on these horizontal relations between states have anything to do with these vertical relationships between state and human beings? That's a perfectly legitimate question. Let me refer then back to the case in the introduction, the Hernandez case. How does it make any difference in the Hernandez case? What are these lenses you look through to understand international borders? How might his family's case have looked a little different to the United States Supreme Court, perhaps, if we were to take a different view of international borders and see them as more cooperative institutions? Well, let's go back to now the US Supreme Court. Now look and see what the minority said in this instance. The dissenting judges in the Hernandez case provide a clue as to where I want to take my argument. They recognized that the shooting took place in a special place where de jure sovereignty should not have determined the protections that Hernandez should have been entitled to and the remedy for his family. Most telling is their description of the culvert itself as a special border-related area, sometimes known as a limítrofe area, that Mexico and the United States had worked together to manage over the years, and which, and when it was constructed and completed, President Johnson himself proudly went to the border and celebrated this bridge between cultures, between friendly nations, as a joint effort. The United States and Mexico had worked together for decades to maintain this area and this infrastructure, manage the water. So they talked about it in these kind of cooperative areas. Justice Breyer's dissent then shifts towards what international law has to say about such spaces. Quoting, international law recognizes special duties and obligations that nations may have in respect to limítrofe areas. Those areas are subject to special obligations of cooperation and good neighborliness. He described these spaces as regimes of voisinage, where neighbors work together to achieve their common interests. Thinking about the border this way, there's something totally arbitrary about the question of whose territory was a teenager on. Just a few more feet north, and the case would have been deemed an excessive use of force case, and there would have been a remedy in that instance. One likes to hope there would have been a remedy in that instance. But instead, the majority viewed it as an international incident involving national security and beyond the court's scrutiny. Viewing the border as a collaborative project between neighbors provides one perspective, and seeing it as a dividing line on the ground, a completely different, essentially. So I think it's important then to turn our attention as to why that would be. Why should we think of a border not just as a line? Why should we think of it as a different way of ordering relationships that involves somehow neighborly relations and issues of management? And I want to sort of suggest that we should be thinking about borders in terms of their relational consequences. All borders have consequences, and they are relational in a very, very clear way. So to return to our argument, there are two major consequences to bordering. They divide line, they divide territory, and that's the territorial approach. And it's heard, for example, in the sort of early 20th century pronouncements of people like Lord Curzon, who says that to claim territory is to deny it to others. And this view sees that, quote, the least encroachment on the territory of another is an act of injustice. That's the dividing line kind of an approach. That's the kind of general view that is assumed by the majority opinion in the Hernandez case. So what matters in this view is the sanctity of the division itself. It's a symbol of state sovereignty. But from another perspective, borders are essentially relational in nature. They order social, economic, political, legal relationships in what would otherwise be very smooth jurisdictional space. That's what they're intended to do, right? They're intended to create disjunctures like this. A set of rules over here, regulations that are different than in the country next door. You have taxes that are different here than in the country next door. You have services here that are different in the country next door. And those are meant to, a border in this sense changes those relationships by its mere intention. That is what it's meant to do. That's what it's intended to do. And that is often, very often, what it does. So we have to think of the border in this case as kind of a profoundly affecting social relationships in space. And there's almost no other reason to border unless that's what you want to do. If you think of it that way, it's the essential purpose of bordering. So bordering in this view is a dynamic process that affects how people interact. And viewed in this way, it's got inevitable consequences then. Inevitable consequences. Borders are governing relationships. Some people are privileged and others are, their desires are suppressed. People find ways to circumvent borders. Differential regulatory regimes, tax structures are going to encourage smuggling. Borders create economic place premiums, is what the economists like to call it. Place premiums, places where your life will be better off for all kinds of economic reasons compared to, and usually this is governed by the wage differential between two places, for example. And so, market segmentation is a big reason for border as well. So these are real consequences. And you know what? People try to work around those to improve their life chances. Absolutely need to expect that. It should be absolutely no surprise. What were we expecting, right? We were expecting these differentials, and now they need to be governed. My issue. So these are economic incentives, but sometimes families are split as well, creating a desire to visit the different side of a border. Sometimes identities are pulled apart. That is, sometimes the border slices people from the places that they most identify with. And I think, one example of that is just this whole idea, again, in the southern border of the United States, the idea where indigenous communities have been in place for a very long period of time. And they are now restricted from easily crossing the border from one side to the other. And the protest movement has been, we were here first. We were here before the border was. We didn't cross the border. The border, in fact, crossed us. And so these are all kinds of challenges. Some of them are economic challenges, but people resist certain kinds of disadvantages that bordering deals to them. They're utterly foreseeable kinds of challenges. States should expect them, that these costs are being imposed, and they should then expect to have to maintain the border to deal with these kinds of challenges. Okay? So that's where this is going. And this is difficult. It's difficult because these are very liminal spaces. So there's sort of spaces where people want to sort of move from one side to the other. You've got a neighbor next door whose formal sovereignty is, it's a non-hierarchical kind of law governing sort of an area. There's a blur between what's in and what's out when people try to move from one place to the other. So there's a lot of challenges to do that. But the important thing, I think, is that it is this move to bordering that creates responsibility around dealing with the consequences. So that's where I'm going to take us next. And what tools do we have to try to deal with such a thing? I'll be talking about now ways we can think about this. This is not a new problem. not a new problem. It's not, sort of not invented around the last 20 years when we see there are challenges to international borders. You know, people have been divided in space not forever, but for long periods of time. And there are plenty of analogies we can turn to. So I want us to look for a minute at general principles of law to see how human ordering has sort of been thought about and regulated. When you create distinctions, giving some people rights and other people not those same rights, how those kinds of differences are managed. So now what? Borders define these relationships, and now we need to deal with the consequences. Okay? And mind you, we're in an area, of course, where the Lotus Principle is in full bloom. You know, whatever international law doesn't deny you can do, you can legally do. So we're fighting against kind of this idea about, you know, well, where's my explicit obligation to do that? I want to offer some possibilities for thinking about more responsible and more collective border management. So the logical step that is going to suggest that there needs to be more attention to governing these relationships can look like an argument that kind of unfolds a little bit like this. Borders are of general concern to the international community as a whole. They tried to establish through treaty law. The consequences are predictable. Borders must be governed. How they are governed is also of concern to the international community. We can think of some ways to do that. Okay? So borders, in this sense, they encode these sets of rules for behavior from which a state is not at liberty to withdraw unilaterally. Just like when we were talking about treaty law and drawing a line, the obligation to manage predictable problems around borders, you cannot withdraw from that, from unilaterally and irresponsibly either. Okay, so that's the crucial if-then statement. If states have a duty to contribute to the public good of stable borders, as we've seen in treaty law, then they also have duties to maintain them in ways that contribute to the international public good as well. After all, think of it this way. States have benefited from the international society that invented them, that supports their sovereign status. States owe obligations of responsible border management to the international community. Now, where can we start to think about obligation here somewhat intentionally? It's a little strong, but I want to use it intentionally because I want to try to make the argument that there is some good law around this area. And I use this word because even though there's no international convention on state responsibility with respect to borders, and even after tomorrow, there's still not going to be a suggestion like that on the table necessarily, I still think that there are some principles of law that we can turn to. General principles of law here might be useful. After all, as I mentioned, humans have claimed a right to bounded space and bounded goods for centuries. Okay, so we can turn to this area. General principles of law, I fully understand are not thought of as a sort of primary sort of source of obligations primarily. I understand custom, and I understand that treaties in particular are kind of the most clear go-to kinds of sources of law in this area. But let me for a moment sort of turn back to what Hersch Lauterpacht had to say about general principles of law. And he noted that general principles are crucial to supplement treaty law and custom. They are especially useful, his ideas suggested, for thinking about how to handle problems or old problems that take on new significance as circumstances change. So there's a connection here, I think, with one of the themes of the namesake of this important center. So general principles of law can also be thought as rather flexible and can keep international law responsive to changes on the ground. We can also be skeptical. We can be skeptical because we know. There's a footnote here. We know the well-known difficulties of coming up with a commonality of sort of what constitutes a general principle of law and representativeness of such rules. And yet, I think I'm going to offer the possibility that there are legitimate sources of international law in this area that flow from principles. And potentially useful to bring kind of a new lens to focus on cooperative bordering. And the first one I want to think a little bit about here are property law. Property law. And in particular, I want to think about property law and a particular theory of property law. Property law is essentially based on social obligations of ownership. Is the theory that I want to try to develop here. Are there social obligations to sovereignty? So when I think about these as just a little bit analogous here, property law provides these potential insights if we're willing to use it as an analogy to sovereignty. The goal of property law, like international bordering itself, is to establish stable human relationships as they relate to valuable things. Property relationships must be defined, delineated. We create these categories of owner and not owner. And arguably, this is akin to the project of defining territorial boundaries between states. In this sense, international borders and property rights are similar in their relationality, the relationships that they try to regulate. So we need a theory of border obligation, I think, that recognizes that borders are grounded in the values and interests of the broader collectivity. And some theories of property law actually do this for us. They found rights and obligations in the social context in which property is based in the first place. Property law, in this view, serves a broad range of social goals, which themselves are subject to change over time too, by the way. And a common thread can be sort of found in a wide range of property law principles, from antitrust to fair access to fair housing, that property rules serve the social goal of promoting widespread access to the valued resources needed for human life. So if that's kind of a social understanding of why we even have property laws, why do we have property laws, then I suggest that might potentially be an analogy for states and their sovereignty, their territorial sovereignty as well. For example, in the German basic law, comparative property scholars have noted that there are principles there's the principle that ownership entails obligation, and it grounds property law in the fundamental principle of human dignity. This line of thought emphasizes that property law encodes social goals. While different societies value different things and may strike different balances, the nature of property is of society that created those goals and created the property rules. So private obligations, social obligations for private owners follow from this. Property owners have benefited, after all, from the society that gave them their property rights, the community that supported their private accumulation in the first place. So for the sake of, we can think of a lot of ways this is true. For the sake of community character, private property owners may be subject to historical preservation rules, for example. For the sake of human flourishing, maybe to provide roads or schools or hospitals or all of this kind of sorts of things that Charles Taylor, I just love this phrase, referred to as mundane infrastructures that support human agency. All kinds of reasons, property law has rules about eminent domain. We need to do some social provisioning and build that into understanding of property law. In fact, property law seems to suggest and how to define that sacrifice is sometimes an aspect of entitlement. And as a general principle of law, this theory embeds property rights and obligations in broader norms of social obligation. So let me try this out on you. Okay. So what I have up here on the left is essentially straight quote from Gregory Alexander's work on kind of social theory of property law. And what I'm asking is just to imagine for a moment if we were to do a little bit of substitution here and understand that there might be an international analogy that would be quite useful here. And the meaning of this analogy for borders is reading the following. Border law serves international society's social purpose of promoting systemic stability and widespread access to fundamental modes of human flourishing. We have international law and state sovereignty for a reason, and it's not a reason in and of itself. It is for human flourishing. And so this analogy suggests that some egregious methods of border control are no more a mere national interest than is the interest of a private landlord who excludes tenants on the basis of race. If we can accept that analogy. In both cases, the owner is obligated to follow community restrictions on use. Interests of the international community are rightly engaged when states assert a right to control their borders in ways that violate international community values, those reflected in fundamental human rights. Property law, broadly speaking, is centrally concerned with relationships in the same way, in a similar way that sovereignty and international borders are. We can think of this in a lot of other ways as well. We know, for example, that there is a common law of nuisance, and we see it showing up in a lot of areas that we consider sort of international good neighborliness, for example. And it requires essentially that property owners not use your land in such a way as to injure that of others. And this offers a general starting point for thinking about bordering relationships as well. So all kinds of rules we can think along these lines essentially have sort of, I think, are connectable with the international law of good neighborliness. Refraining from nuisance, I think, is reflected in or kind of analogous to some of the things we see in international law of good neighborliness. Refraining from nuisance, for example, is the law of good neighborliness is rooted in the United Nations Charter, whose preamble requires states to live together in peace and with one another as good neighbors. Article 74 requires states to take into account the interests and well-being of the rest of the world. And while the UN Charter universalizes these, I also think that there is an especially important aspect in which these principles are rooted in proximity, that it's especially notable that they be applied with a neighboring state. And that's why I think it's so applicable to borders. Because the Charter tries to generalize this ensemble of conventional and customary rules that regulating mutual relationships between neighboring spaces and adjacent portions of and their territory ought to be sort of generalized globally. But neighboring should, it seems to me, begin at home. So these ensemble of norms comprise international law and neighborhood. They originate in familiar negative duties of states, not to attack your neighbor, etc. But that might not be enough. There might need to be positive obligations as well. Good neighborliness is central to the governance of proximate human relationships and natural environments and interdependence generally. And I think it's well recognized in international environmental law, for example, that externality can't always just be remedied negatively. They have to sometimes be proactively managed, cooperative. International environmental law understands this, that harm can result from inaction as well as from action. For example, international courts have held that international neighborliness in the environmental area implies that states have a positive duty to warn others of harm, to engage in meaningful negotiations to avert harm, and to cooperate when interests of a neighbor are at stake. There's a citation for every one of those, but we're not going to go into that right now. Principles of preventive action, arguably from some kind of rules of due diligence, have governed the international environmental space for quite some time. And in fact, the International Court of Justice has even developed procedural standards for preventing and not just restituting harmful environmental effects on neighbors, including the conditions that might even trigger a duty to perform an environmental impact statement. There's no particular reason why these standards should be limited to the environment. There's no particular reason for that. We're used to seeing them in that area, but it strikes me that bordering has consequences for this broad spectrum of human life, for where people live. Their lives are territorialized by the law of bordering. It affects where they live, where they can work, where they invest, where they pay taxes. Every conceivable aspect of life is affected by bordering. So we need to be thinking of the broad spectrum of human activity that could potentially fit under these standards of good neighborliness, ones that we're quite familiar with in the international area. And I can't spell out all the details for every border on earth of what good neighborliness would look like. But as a first step, I think it's useful to point out that general principles of law might at least suggest that states might have a legal obligation or duty to think along these lines. Now, simply to conclude very quickly, to each state their own sovereignty. The border is a collaborative institution whose governance engages central concerns of the international community as a whole. And, of course, human rights are universal. So now it seems to be necessary to remind states that border zones are no exception. National security needs to be scrutinized, not simply presumed to be at stake. That's why I find it appropriate one more time to refer back to the Hernandez case. The cross-border shooting of an unarmed child at the hands of a border patrol agent was met by the U.S. Supreme Court with uncritical narratives of danger and national security. The majority saw a line and never considered basic human neighborliness in thinking about the nature of that line. The Hernandez dissenters took a different view of the border. They did not see a line only. They saw relationships of espionage, which should have obligated the United States to compensate its neighbor for the death of their son, as required by the International Covenant on Civil and Political Rights, which both the United States and Mexico had signed and which obligates states to provide a remedy in such cases. So that was passed over, largely because of the understanding of the international border as merely a line that creates a division. So to conclude today's discussion, borders shouldn't be places of legal exception. They should be governed by general principles of law and especially by good neighborliness. My approach is not intended in any way to undermine universal human rights norms contained in treaties and customs. I just want to flip the script when it comes to the idea of borders and to reclaim their cooperative roots and the rejection of unilateralism around border areas. The turn to general principles of law suggests limits to a unilateral entitlement of border control when unfettered exercise of that entitlement violates norms of the international community. Tomorrow, I'm going to explore some ideas of what this might look like. And I hope I see you all again, and I hope especially I see you on Friday, because I need more good ideas. And one reason I do this is to essentially reap what the audience might have to offer when it comes to thinking through what some of this logic would imply when it comes to bordering. So thank you very much, and I hope to see you tomorrow.
So much, Professor Simmons. That was fascinating. The reminder that by convention, we do the question answers on Friday at 1 o'clock. But before that, please do join us again tomorrow at 6 p.m. for the third and Friday morning. Yeah. And then tomorrow, Thursday at 6 p.m. for the third and concluding lecture of this wonderful series. Thank you again.